thank you for the introduction. And yeah, again, hello to everybody who's here. Quite a sort of broad subject today, really, to talk about. There's been quite a lot going on, clearly. Not a huge amount of employment law, but I think in terms of being an employer and having a kind of COVID secure workplace and having consideration for what that means when you employ a personal assistant in the current climate is what I will touch on today. I don't want to talk for too long. I'm kind of conscious that we might get bogged down in the slides, and I think the Q&A session might be kind of what more use to you. But I have got some slides which we'll work through. If you want to stop and ask questions, either type them in or let us know, and perhaps you can be unmuted and we can have questions as we go. Because if there is a burning issue, it would be good to have those kind of as we go, really, in the context of what we're saying at the time. So,
David, are you able to keep an eye on the wait room, because someone will be coming in at about 1:15?
Yeah, I can. Yeah, I've got the chat box open, and I'm not sure if I can. Yes, I should be able to. Yeah.
Okay, so someone should be transferring over now, just so you know.
Okay, right. Yeah, okay, I should be able to, I'll keep an eye on that, yeah. Okay then, yeah, so, sorry, from Chris there, David may need to know that PM has just announced that new COVID restrictions might last until March, which might be pertinent to today's discussion. That's very true, Chris. This is quite telling. So we've just had a message there, if you can't see the message, group chat to this meeting from Chris, suggesting that there has been an announcement by government just now regarding the COVID restrictions that may last until March. And I think it's such a fantastic example of what I was about to say, that the pace of change over the last, well, since March really, has been kind of really unprecedented. The scale at which of what's been happening and the different kind of government reactions, guidelines, has been really difficult to keep up with, especially in the initial kind of phase. And I think because we're dealing with a movable feast, with something that's changing, with something that's having to be constantly analysed, where there is a desire from government to get everybody back working, back at school and back to normal life as much as possible. But they're up against something that is, subject to change. It's a virus and it's not going away. I think there is a bit of a tension there. And I think what we're seeing is a kind of seeing that tension play out with politically, and that's very, very difficult to navigate at times. So, but anyway, we'll come back onto that. So you can see there the agenda. I wanted to just introduce who we are. I will talk about being an individual employer and a little recap on what we mean by that. I was asked to mention employment status. What's a self-employed PA? Again, these are big topics, and these are things we could talk for hours about. I could talk for hours about, and I don't want to, my job isn't to send you off to sleep this afternoon. So I'll try and avoid that. And then returning to work after COVID, as I said. So a little bit about the kind of current situation. So I hope that's okay for everyone. Let's see if I can get these slides moving. So yeah, Mark Bates Ltd. Who are we? Most of you should know who we are. We are the home of Premier Care. You might know us at Premier Care or Mark Bates Ltd. We are currently contracted to provide insurance for direct payment recipients in Kingston who are supported via KCIL. So if you are employing anybody on direct payments, the likelihood is, or fairly certain, that you'll have one of our insurance policies. So that's who we are in this context. And you can see there, I won't read through all of that. I don't want to read it word for word, but one of the key things there is the fact that we are a family-run business, and we're based up in Lincolnshire, in the Midlands. I'm based in Somerset. I cover the south and southeast, and that's why I deal with you guys in Kingston. And yeah, we are a family-run business, and it's, as I say, feel free to kind of read through that. But our principles do set us apart, and I like to think we've shown that through the COVID period, where we've been as supportive as possible to our policyholders and organisations we work with. Very quickly, if you're not aware already, you'll be aware these are some of the policies we provide. The home employment insurance policy is the one you are likely to have if you are receiving a direct payment in Kingston and you have a PA. If you have self-employed PAs, you might find that they should ideally have their own public liability insurance. They may have a policy with us, our personal care assistance policy. They may have a policy from a different provider, but the hope would be that they do have their own public liability insurance, so that picks up any liabilities they have in the workplace. And then, of course, we have mobility scooter cover, travel insurance for people with pre-existing medical conditions and standard cover, and again, adapted home insurance and cover for in-home equipment. So that's just an overview. That's who we are. Obviously, if there are any questions, let me know. But what we're here to talk about isn't so much what we do, it's more about what you do, which is being an individual employer. So I thought I've got a couple of slides just to sort of warm us up. I might need your engagement on this, actually. So I don't know how many of you are quick typers, or if you're able to unmute and get involved. Or, you know, if not, I can do it, but it would be good to have your involvement. So we've got a slide here just to warm us up, really. So why do we use a direct payment to employ? I just wanted to ask you guys really what you felt the benefits were to that. And then what we've got here is a bit of a seesaw. And I want to, you know, I'm suggesting there that the benefits do outweigh the barriers. And I just wondered what you guys thought about that. And if you had any suggestions about what the benefits might be. Why are we all here talking about this? Why do people use direct payment to employ their own PAs as opposed to a more traditional method of, you know, service provision, care agencies and the like contracted to councils? Why do we do it? Does anyone have any ideas what the benefits might be? Melvin, more control over how the support is provided. Absolutely, control is a big one, isn't it? Absolutely. Chris is saying to achieve maximum independence. Okay, that's great. So control and independence. These are the two big things that are going to probably pop up on this slide. Anything else spring to mind?
Consistency of PA support.
Thank you, Anne. Yes, consistency is a big one, isn't it? I think that might even be the first one. Let's see.
And I think also the second for me is it's not only the flexibility, but it's also the fact that you choose, you recruit the people that you would like. So when you advertise, you may get, say, one time you might get 2 people apply, another time you might get 10, depending, but at least at the end of the day, the final choice remains with me or with the person that's recruiting.
Absolutely, thank you. That's fantastic, and that's really filling the gaps, I think. So flexibility and continuity, consistency, I guess, is in that. Choice and control, and you mentioned choice there, and it is about choosing who you want to support you in the way that you want. And these are things we kind of, you might take for granted now, but actually we're hard for, you know, that it wasn't always possible to have a direct payment, and there wasn't a kind of independent living movement that kind of pushed for it, that pushed for the law to be changed. And it was changed in the 1990s after lots of kind of little pockets where people were having, I guess, indirect payments, technically unlawfully, but showing and demonstrating that if money is given to individuals in lieu of a service, that those individuals are just as well placed, in most cases better placed, to utilise those funds for the outcomes that they need to meet. Sorry, Chris, did you want to speak?
No, sorry.
No, okay, no, that's cool. So independent, yeah.
Oh, sorry, David. I was just thinking another very important aspect of which comes within these 3 categories is the fact that the people you employ come under your job description, which means that they can assist with jobs that you really want done. So for example, and this is so important, my situation in the last 2 weeks has changed quite dramatically. And I've been able to ensure that my PAs are able to do those jobs, that if they haven't got training, they get it, and so on. Whereas, you know, and they work out they work out between us who's the best person for that particular job, and so on. So I think that's really critical. We can do jobs that agency staff won't even touch, and I think that they're such fundamental jobs. It's not as though they're high powered or anything different, they're fundamental. But, you know, the agencies can't do them. They're not given time to do them either.
Absolutely, no, I completely agree. And I think again, I mean, it just illustrates, it brings to life completely the why people do it and what the benefits are. So I mean, that all sounds great, and obviously for most people it is. Why? What are the barriers? Does anyone have any view about what the barriers are? What puts people off, do you think?
The high cost of it's the high cost of what their contribution is called for by the local authority, really.
So contributions, but actually I agree with that, John, but I think if you have a contribution to a direct payment, if you chose not to have a direct payment, my understanding is your financial contribution to your care would be the same. You would still have to contribute if you took a traditional service financially. But I take your point. But I wondered specifically what the barriers were to the option of a direct payment. Why we wouldn't want those things? What are the things that you have to do practically day to day that you wouldn't otherwise have to take on board?
Can I add something else?
Yes.
Sorry. If other people want to speak, if they'll indicate, so I don't have the first, I'm not first all the time. But it is important that for some people, the barriers are lack of confidence.
Mm-hmm.
They've always been done unto. So it's terribly critical that, we help people to have the confidence, first of all, to do it if they haven't got that. There's also the barrier of choice. Sometimes if you advertise and it's quite expensive, you may get good response, you may not, and that worries people. Obviously, if you're and also if you need to recruit in a hurry, people get so frightened that they won't have any backup or they don't know what to do in an emergency. So I think, there's a lot of training for disabled people often that needs to happen before they get onto a direct payment.
Yes, absolutely. Any, what have we got here from Melvin as well? So accountability, from Chris to RBK. So you are accountable. From Melvin, managing payroll, finances, HR disputes. I think that's it. I think,
paperwork.
Sorry, please can I let somebody in? Here we go. Let's do that. Okay, there's a couple of people coming in. Brilliant. Welcome to those who I've just admitted. So yes, accountability, managing payroll, inability to recruit PAs. Okay, so we're getting there. So slowly but surely we're teasing out the barriers, and they are very serious barriers and genuine barriers, aren't they? And I think managing staff, for me, the big one is, responsibility generally, really. Within that, you could include accountability, responsibility to managing staff, responsibility as in our legal obligations that we take on. As an employer, you are responsible in a way for your PA in a way you're not responsible for a carer who comes from an agency. You have obligations to them. In law, you're now your legal liability. That's different to having a carer from an agency, isn't it? So what comes with the independence, the choice, control, the flexibility and continuity is this added responsibility. It's part of the deal, isn't it? And what I think comes alongside that, how does that deal work? I think if you just said to people, right, here's some money, go off and employ somebody, I think you're almost being set up to fail. I think there needs to be support, and for as long as direct payments has been around, there's always been provision within each local authority for you to access support. And that's what, in this context, in Kingston, KCIL are there to do. They're there to support you. And that's probably what's missing from this slide that's just popped up. So you have a direct payment and you are supported to manage. You're supported to manage those responsibilities. You're given information about what those responsibilities are and how you are able to meet them. And as Anne said, people are perhaps have always been done unto them, as Anne put it, and I think that's absolutely right. So there is a requirement, peer support and local support, to give people the confidence to take on those responsibilities and flourish and then have the benefits of direct payment. That's kind of how it works. In terms of where we fit in as an insurer, we provide some of those, we cover some of those liabilities for you. It's funded from your direct payment by the council. You pay for insurance to pick up some of those liabilities for you. You have a payroll provider. I think in your case, many of your cases, probably Pay Packet. And they're there managing your payroll, in some cases holding the money for you. I don't know if they use the managed account there. But there are lots of services around direct payment recipients that are in place to help you manage your responsibilities. What you can't do is sidestep the liability, the responsibility, but you can access really good support. And it's knowing where to access that support and how, which I think is really, really important. But that was just an overview introduction really to, you know, my view and our view of using a direct payment to employ personal assistants. So what I also wanted to mention, by the way, if there is anything you want to say, please do say. I'm just looking at Chris, inability to recruit PAs, yet technically payroll can be managed via PayPal or something similar. Absolutely, thank you, Chris. So 4 golden rules for direct employers, and this is just something, because we don't have much time today, that I like to talk about. I think it's really, really important if you have a personal assistant, even if they are your friend or you have another relationship with them, they're a neighbour, a family member, it's really important to take time out to talk to your PA. And it can seem very obvious. You might not have time for an official meeting every week, but 5 minutes here and there, you know, make sure you're making time to talk, explain how things are going, let them know how you're doing, how the job's going, and listen to what they're telling you. You know, how are they? Ask them, how are they? How's it going for them? And make sure you're having regular dialogue about the job, about the work, about how things are working. If you have that, then you're more likely to pick things up. You're more likely to have a healthy working relationship with that person. Similarly, alongside that, I would suggest keeping written records. So whatever the issue is, a written record of it, a note in a diary, a day per page diary, I suggest is a really good idea. I have an A5 day per page diary here that I use for work, and I would suggest if I employed anyone on direct payments, I'd have something very similar. It just means you have a record. Anything that's agreed, anything unusual that happens, whatever it is, an injury, you know, however informally you manage your direct payment, and it is okay to manage it relatively informally as long as you're taking your responsibilities seriously. You know, you should have a written record of things really that you can refer back to and that will support you in the event that a dispute or an issue occurs, and you have something to refer back to. And actually that is for your own benefit, but also for your employees, because your employees will be comforted to know that if they do have a discussion with you that might be something they've raised, that you've kept a record of it, that there's some way of looking back to see what was agreed on that day. So I would absolutely recommend that. And finally, I would suggest know when and how to seek advice. So I've got a payroll problem. My pay slip hasn't gone to my PA. I would like at the front of that diary, perhaps, to have a list of phone numbers. And the first one might be KCIL, direct payment support issue. I go to KCIL. I speak to John or I speak to Maria, whoever it is you speak to, have that number there and remind yourself what that's for. Similarly, if it's a payroll inquiry, you know, have pay packets number there, so I know who to phone when it's a payroll inquiry. If it's my financial monitoring and I've got a problem dealing with the council, who is the person I ring in the council? Or what's the number or the email address where do I communicate with if it's an issue around my financial monitoring? And my social work team, what's the duty team number if it's a care issue, if you feel like you need a reassessment, if you're not satisfied with the care package and you need to talk to someone about that. You know, having those numbers clearly defined and marked out, and knowing, you know, who's who and what people's job is really is useful, because, you know, while things are going well, that's great. But if something's wrong, it's useful to have those, knowing who to contact and when and how in the event that you need them. So those are just some basic tips for me, which I hope are useful. What have we got here? Sorry, I'm keeping an eye on the chat as I talk. Oh, right. Sorry, Kimberly is just saying to those people who have signed in, do introduce yourself in this chat function. You can also ask questions here. Absolutely. Thank you, Kimberly. Yeah, absolutely. And, you know, you can hopefully chip in and just contribute, and I will gladly try and pick up what I can. So in terms of the presentation then, what are our legal obligations? I mentioned them earlier, and I thought it'd be useful perhaps if we just ran through what I think are some of the core legal obligations for employers with regards to personal assistants. Okay, so I think we need to think about being insured against injury. Now, I would say that because I'm standing here talking from Mark Bates Ltd, and we are an insurer. However, I should say that my personal background isn't insurance. I've worked at Mark Bates Ltd for 5 years. I did work for another insurer, Fish Insurance, before that. And but before that, and for many years, I worked for local authorities, and I worked in the London Borough of Islington, and I worked in local direct payment support services for a number of years before that. So I've kind of been around direct payments for a long time. But insurance is, I would suggest, really, really fundamentally important. It's a legal obligation for you as an employer to have employer's liability insurance. And employer's liability insurance means that in the event that an employee of yours is injured or falls ill while working for you, that you are able to meet the cost of a compensation claim against you. And we give you up to 10 million employer's liability in our policies. So if any PA is working for you, following your instruction, and they have an accident or injured, they will be covered if they claim against you for loss of earnings, for any compensation. You have to have employer's liability to pick up those kind of claims. The majority of claims we see on our employer's liability policies are things like back injuries caused by slips, trips and falls, and manual handling accidents and incidents. And that's the first, I would suggest, legal obligation to consider. You should also make sure that you are paying your staff at or above the national minimum wage. That's really, really important. Does anybody know what the current national minimum wage is? You can pop it in the chat, perhaps. Melvin suggested HMRC and tax responsibilities. Yeah, absolutely. Right to work, training, pensions. We're going to mention those things in a second. So we need to make sure that we pay our staff at or above the national minimum wage. And your direct payment rate from the council should and will enable you to do so. And you'll notice that the direct payment rate you get is higher than the national minimum wage, because you need, as the employer, additional money on top of that to cover some of your legal responsibilities, because some of your legal responsibilities cost money, don't they? And that's what Melvin's suggesting there. The HMRC, Her Majesty's Revenue and Customs, you are an employer. They are going to look at what you're paying your member of staff, and there is potentially going to be liabilities for you to pay over to the HMRC by way of employers' national insurance contributions, your employee tax and NI, and that's your responsibility to manage that. Now, you have a payroll company who are managing that for you, but it's your liability. The money in your direct payment is paying for the payroll company to manage that on your behalf, but you're the employer, it's your name, it's your responsibility. But as I say, getting it clear on what each organisation is doing for you is very important. So we make sure our staff are paid at or above the national minimum wage. We make sure we keep them safe at work. Health and safety is a legal obligation for all employers. So there is a general obligation in law that you must keep your employers, provide a safe work environment for your employees. That's for everybody. So whether you're a big employer with hundreds of thousands of staff, right down to an individual employer with one staff, you must keep the workplace safe. And you do that by risk assessing, by considering hazards and minimizing risk. So you look at hazards, identify them. Can I remove that hazard? Or if I can't remove it, how do I mitigate it? How do I minimize the chance of there being an injury? And you engage your PA in that process. That is a risk assessment. It's looking at the task, it's looking at the environment, and it's looking at the person doing the task, and it's considering the risks. And sometimes some of those things change. Sometimes the task changes slightly. Sometimes the environment in which the task is being undertaken changes. Sometimes the person doing the task changes. If you have a personal assistant who becomes pregnant, for example, you need to re-risk assess, because there will be different risks attached to doing that task as the pregnancy develops. So it's a fluid process, health and safety, but it's your obligation to make sure you're considering it and keeping your workplace safe for your PAs. And it's a two-way street. PAs need to work with you. They need to tell you when they identify a hazard, and they need to tell you when there's a requirement for them to be trained when something's not right, so that you can then respond. So health and safety is an active process that you really need to engage with your PA in and with and about on an ongoing basis. Written risk assessments are a very good idea. And you can contact us for support with how to do that. You could also have a health and safety policy. It doesn't have to be a really long policy, but you could have one. If you have 5 or more staff, you have to have a written health and safety policy, and you must have written risk assessments. If you have fewer than 5 staff, it's not a requirement in law to have a written policy and written risk assessments, although I would suggest to you that it's a very good idea to do so, even if they are fairly basic, depending on the work that's being undertaken. Now, another legal obligation we need to think about is to assess and potentially enrol our staff into a workplace pension. The government changed the law in, I think it was way back in 2008, but it was staggered. So we got this process a few years later of staging something called auto-enrollment, which some of you will remember. And it meant that employers were now going to have an additional duty to make sure their employees were pushed into a pension scheme if they earned over a certain amount of money. And I think there's a slide later, which I won't go through in detail, but when the slides are sent to you, if you are interested to learn more about that auto-enrollment, there is a slide which breaks it down slightly. But the upshot is that as an employer, you are duty bound to assess that member of staff based on their age and their salary, and then potentially put them into a pension scheme. And again, your payroll provider will do that for you, but it is your liability. You need to make sure they are doing it for you and liaising with pensions providers. You know, your employee can opt out or they can opt in. Once they've been put into the pensions, assuming they are eligible, but they can't choose to opt out until they've already been opted in. So there's quite a process there that needs to be managed by your payroll provider. If they earn less than £10,000 a year, the rules change slightly. But in either case, if they earn over, I think, roughly £6,000 a year and up to 10 or over 10, then you will be contributing. So some of your money will be going to the pensions pot for your PA. So all of this can be managed for you, but it is a legal obligation that our employers have. There's a question from Chris. London living wage applies here, David, so we pay above the living wage nationally. That's fantastic. So the London living wage is great. It's not a statutory requirement to pay the living wage. It's not the law, but if it applies in your local authority, if your local authority have signed up to the London living wage, then there is an obligation that the council are making to ensure that everybody receives, I think it's £10.75 or £10.55 per hour. So that's great. So that for you guys, you should work to that figure, because it should, of course, £10.75. Thank you, Mel. So it should, of course, fall back down to you as direct payment employers in the same way as anybody working for the council. So it's same principles as paying a national minimum wage, but we're up to £10.75, which is really great and healthy and better for PAs. That's great to hear. So permitted to work in the UK. We need to make sure our employees, our PAs, are eligible to work in the UK. Things that catch people out are temporary visas. Visas have expiry dates on them, so be mindful of that. If you employ somebody after their visa has expired, you will be breaking the law. They won't be eligible to work in the UK, and you are liable to be fined significant sums. We had a direct payment employer in North London a couple of years ago who had a letter suggesting she would be fined £10,000 for employing somebody whose visa had expired. It did in the end. She didn't suffer that fine because there was some support she received and letters were sent and explanations were given. But it was quite pertinent for her because it reminded her, I am the employer. The letter was addressed to her. It wasn't addressed to her payroll company. It wasn't addressed to a support organisation or to her local authority who provided the funding. It was addressed to her, and she was the liable party. And that's the thing I think we need to remember at all times. Personal data must be kept safe and only used for legitimate purposes. That's really important. I'm sure many of you are thinking of 4 letters in a very specific order now. And I bet if I asked you to write it into the chat box, somebody could write it and it would be the same 4 letters. There we go, Melvin. Thank you very much. GDPR. And it's like it's the European legislation around data protection that was introduced a year or 2 ago. We already had the Data Protection Act. Data is personal data, which is any data that can identify somebody. Is something you need to take very seriously, how you manage that as an employer. We already had fairly strict rules around that. GDPR brought things up to date. It's a European piece of legislation that just ups the ante a wee bit. So employers now have to be even more careful about consent, and you can't rely on kind of generalized consent. It has to be very specific, and you should be providing privacy notices about how and why, the legal basis for why you are holding data and who you are sharing data with. Now, as an employer, you're sharing your PA's data with, in some cases, PayPacket or whoever does your payroll. You know, you are doing that. So there should be some account taken for that. And we have templates, guides for privacy notices in order for you to manage your GDPR requirements that we can support you with. I should have said that the policies we provide, as much as they are employers' liability, provide you with other covers like personal accident cover, redundancy cover in the event that you have to make your PA redundant. But crucially, what it does provide you with, if you're not aware, is advice around, is legal advice as an employer. So if you have any issue at all or any questions about any of these legal obligations or being an employer, you will get support locally from KCIL. But to supplement that support with your insurance policy, you are also entitled to contact us at any time to speak to an advisor under your policy and have questions answered, and also to support you through issues. So if you had to have a disciplinary with a personal assistant, the idea is you would have support to manage that situation lawfully and safeguard yourself in the event that that PA wanted to take the situation further or was unhappy with the way they were treated. Also, another legal obligation, issue a written statement to all employees and workers on day one. So the day your employee starts work, they are entitled to receive a written statement, which is just a written contract which details what the terms and conditions are. That is a legal requirement. We actually now have on our website, if you log in and create a customer portal, if you create a customer account, which you can do using our customer portal, there is a tool on there that you can populate a contract template, and you can actually have that emailed to your member of staff on day one if you want to use that. You don't have to use that. You can call us and call our advice line and we'll send the template to you, or I'm sure KCIL will provide you with templates as well. So there's lots of options and opportunities to get contract templates to use and issue to your PA. But be mindful that the law changed in April this year. We used to have this period of 2 months to issue those contracts. We now have to do that on and from day one. Wow. Okay. So that's a whistle-stop tour through our employers' legal obligations. I'm conscious of time, so I'm going to have to whiz on. I was asked to mention, yes, I can send out our contract template. That's not a problem at all. Thank you, Chris. Just a question from Chris for anyone who can't see the questions. I'm just making a note of that here, so I don't forget. So I was asked to mention statutory sick pay. Now, this is another legal requirement. Anything with the, yes, it could, that's fine. Anything with the statutory sick pay, sorry, anything with statutory in the word means that it's legal. A legal requirement is like a minimum requirement that you'll have to meet. You're unlikely to have a company sick pay scheme as a direct payment employer, but statutory sick pay will apply. So what do we mean by statutory sick pay? Now, I was going to ask questions of the group, and I was going to ask you these questions, but I think given the timing and how long this has taken, I'm wary of just taking up all your time. So these are the questions I wanted to ask. An employee's average earning has to be above something in order to be eligible for SSP. What is the current SSP weekly rate? What is the maximum amount of weeks an employee can receive SSP? And is statutory sick pay a day one statutory right? Does it apply from day one? So these are questions that you might be asked. If you employ somebody, it might be useful to know the answer to some of these questions. You can always seek support and get advice with it. Your payroll company will help you, but you need to let them know when somebody's not at work and they're sick so they can do the sums. But it's useful to know, when does somebody get statutory sick pay? Does everybody get it? Does it matter how much they earn? So the next slide will tell us. So I think one thing to be aware of, that statutory sick pay is a day one statutory right for your employees. And that means if they start work for you tomorrow and then they're absent for 4 days or more, then they will start to accrue statutory sick pay on the assumption that they will be, on the assumption, yes, we can, Chris. Sorry, Chris is asking Chris that track and trace. On the assumption that their average earnings will be above the lower earnings limit, which is currently £120 a week. So if your employee earns more than £120 a week and they're off work sick for 4 days or more, they will start to be eligible and accrue statutory sick pay at £95.85 a week. So remember, for your direct payment rate, that means that you will be spending £95.85 a week from your direct payment, paying and covering their statutory sick pay. While also you will be asking somebody else or an agency to provide the care and fill the gap with your sick PA who cannot attend work will be the gap they leave behind. So you will be eating into your direct payment budget at that point. And as you can see, it is for a maximum of 28 weeks. So that could get costly if somebody was on a period of long-term sick. With regards to coronavirus, the SSP regulations were changed quite early, and it was backdated to the 13th of March. The changes were basically that you didn't have to wait for the 4 qualifying days if your absence was coronavirus related. If you were told to self-isolate or you'd fallen ill as a result of the virus, you were automatically entitled to SSP from day 1 for 14 days. It was also recoverable from the HMRC. So the HMRC would pay that back to the employer in a way that they do not do so for standard periods of absence or sickness from work. Now, in terms of track and trace and self-isolate, it's the same. If you're contacted by track and trace and told to self-isolate, you will be eligible for SSP. However, I have to point out there are 1 or 2 things that are slightly outside of the SSP, even the amended SSP regulations. So those are, if you are quarantined, told to quarantine and returning to the UK from a holiday or traveling abroad, and you're told to quarantine for 14 days, you are not eligible for SSP. I repeat, you're not eligible for SSP if you're quarantined after returning to the UK. It is simply time off, unpaid. You're not eligible for SSP unless your employer agrees to pay you. You are unpaid for those 2 weeks. Similarly, if you are, as is happening more and more, the parent of a child who goes to school but their year group perhaps is told to self-isolate because there's been a positive COVID case in that year group, you are not eligible for SSP in that situation either. So there are 1 or 2 loopholes or sort of problems where initially the coronavirus SSP regulations were all encompassing. There are 1 or 2 situations now where you will not be eligible for SSP. Obviously, from an employer's perspective, you may agree and have budget and seek agreement from the local authority funding body to allow you to pay staff while they're not coming into work, but that's an agreement you will make rather than a statutory provision. There is talk of, I see Chris has made reference to a £500 payment for those on low pay who are told to self-isolate. There was a pilot for that in the north of England. I haven't got a huge amount of detail on that, but it's a government scheme for those on low pay. So I think the key thing to do on that would be to keep your eye out for the detail as and when that's published. I will have another look for it. But there are some financial payment schemes the government are recognising that low paid people are not able to self-isolate and not work, and there is a requirement to supplement them financially. I think because lots of people were not doing what they were supposed to do on the basis that they needed to live and they needed some money. So there's I will dig out some information on where we are with that and send that with the slides. Okay. But from the employer's perspective, you need to be aware of the SSP regulations and how that works. Okay, so moving on, so that's a whistle-stop tour through your legal obligations as an employer. Why is it important to check a PA's employment status? What are the risks if you get it wrong? Does anybody want to have anything to say about that? By all means, come off the mic or type it in. Melvin says fines. That's right, fines. That's definitely one of the reasons. But who would fine you? Who would fine you if you said your PA was self-employed, but actually you treated them like an employee? Who would take an interest? HMRC, absolutely. HMRC. Who else might fine you? What did we talk about earlier? One of our legal obligations, that we would look at somebody's age and their earnings, and we might have to give them a pension. And the pensions regulator, they look and see who's getting pensions. Remember, the government's intention was to get people to save more money and get into pensions. So if you call somebody self-employed and actually they're an employee, the pensions regulator might take an interest similar to the HMRC and say, you know what, that person should have had a pension, they're an employee. And then they might fine you for not meeting your legal obligations under the Pensions Act. So the HMRC and the pensions regulator. But also, there is another element to employment status, and that's not just the tax end of it, it's the employment law, employment rights. So if we had, for example, and we've looked at statutory sick pay, that's a right that's available to all employees and workers. Now, they have a right to statutory sick pay if they meet the eligibility criteria that we've just laid out. Now, if you call your PA self-employed, but you treat them like an employee, but for tax, they're self-employed, even though you control when they come to work, you tell them what to do, and they're not really self-employed. There's a risk in that circumstance that, they might say, well, I was off sick and I didn't get any pay. And you say, well, you're self-employed, you're not really eligible for statutory sick pay. You don't have statutory employment rights, you're self-employed. They might say, but hang on a minute, you treat me like I'm an employee. I don't have any other clients. I only work for you. I come to work when you tell me to. I follow your instruction. I don't provide my own equipment. I'm more like an employee. Then if they made a claim to employment tribunal and they felt hard done by in that regard, there is a danger that the employment tribunal might assess that situation and say, you know what, we think they do have employment rights. And thus there might be a potential situation where they might claim against you. So it's important to check people's employment status. And for tax purposes, you can do so using the employment status indicator tool. And I've put a link to it on the slide there. So you can get a sense of what the HMRC thinks your worker or your PA's tax status is. And I think in terms of employment rights, it's very similar. It's a slightly different test, there's a slightly different emphasis, but it's all wrapped up in the same thing. Control, and remember what we talked about earlier. We talked about what is the benefit of employing a PA, and we all said choice and control and managing that situation. Now, if you use a self-employed PA, that's fine, but you are relinquishing some of that control. You are giving it over to the PA because they are now in control of the service they provide as a business. They decide how much they charge for that business, and they decide whether they come to you or if they're working for another client, which one they go to. And it has to be that way around. And if you insist on them being there when you say so, and you're in control and you need that control, you're veering towards an employment relationship. So it's just something for you to consider. In terms of self-employed PAs minimum criteria, I would expect self-employed PAs to set up with, register with the HMRC, and get their own unique tax reference that they could show you, purchase their own public liability insurance and any equipment they need to use. They should be responsible for sending replacements when they cannot work, and they should invoice you for payment. So you're not going to be giving them a timesheet and a pay slip. They should be providing the invoice, and they should be giving that invoice to you as evidence that they're managing their own business. Produce a contract for service. The contract and agreement that you have with your PA should come from them. They're the one providing you a service. So they issue it, they negotiate it, and you can negotiate terms and conditions, of course you can, but it's all about where it's coming from, and it should be coming from them. We looked earlier at our responsibilities. You could also, as I mentioned, the employment status indicator tool, and you could seek business references. But the key thing I think I'm getting at is if you employ a personal assistant, if they're your employee, you have responsibilities and legal obligations. If you use a self-employed PA, a lot of those responsibilities, although slightly different, the PA has a lot of responsibilities that they have to take on board. Okay, they might even want to contact the Care Quality Commission to check whether or not the way in which they're working falls under the regulatory requirements. If they're sharing work with other self-employed PAs, for instance, they might need to check on that. So there's responsibility one way or the other. If you're using a self-employed PA, that self-employed PA should be managing their situation and taking ownership of it. Okay. And this is, and I'm not going to read through this, but this is just some case law. Anything in blue on these slides is a hyperlink. And when you get the slides, if you are interested, so if anyone here is interested in understanding the arguments I've just laid out in much more detail in a way that makes, you have this quite heavy going employment tribunal and appeal tribunal judgments. But this case was all about somebody who was placed in a home environment, and she was self-employed for tax, but she was told how and where and when and what way to work. She was on her own, and it was determined that she did have employment rights, despite the fact that for tax she was self-employed. So it's a very good example, if you are interested, to bring to reality the stuff I'm talking about, employment status, These are recent cases from, I think, December 2018. They're very good cases to have a read through. All right, and it explains how the employment status can work. This concepts like mutuality of obligation and control. So it's quite heavy stuff. It might not be for all of you, but it's all there, and I thought it was pertinent to include it in the slides.
David, can I just interrupt you a second?
Yes, of course.
Just
yeah.
a quick question. I mean, firstly, I've got an observation. I think if you follow the HMRC tool on employed versus self-employed, I think if you follow it strictly and you answer the questions honestly, you will find that most PAs are not eligible to be self-employed. That's my first observation.
Mm-hmm.
I mean, I've had this debate with lots of people. Lots of PAs will present themselves as, oh, I'm self-employed. And when we go through the tool, I said, well, there you go. You're not self-employed. I'm providing you equipment. I'm telling you when to work. I am going to be guiding you on how to meet my needs, etc. So if we follow it strictly by the letter of the law, most PAs cannot be self-employed. I think secondly, I think I mean, I don't think really there's an answer to this. I mean, you said several times, if you're relinquishing some of that control, handing over to the PA if they are self-employed, etc. Also, if someone's self-employed, you can't necessarily tell them how and when to work. I mean, I sort of question that on several fronts. I mean, if you employ a window cleaner, for example, and you say, right, this week I want you to wash my front windows, and next week I want you to do the back windows, and actually don't do the front door today. You're still telling that self-employed window cleaner what you want them to do.
Yeah, but a self-employed window cleaner could turn around and say, I'm not going to be doing that today. I'm actually going to be doing it later on this afternoon because another client needs me there. So the point is they have that choice in the end to determine whether they will keep you as their client and when they decide to do the work. An employee just doesn't have that choice. They have to do the window when you tell them to do it. That's the difference. It doesn't mean there isn't an opportunity to negotiate. And of course, it doesn't mean there's some flexibility, but you are relinquishing in the end some of that control.
But is that not true in every situation? I mean, I work for a local authority, and I can decide to an extent when I do certain parts of the job. Okay, it's my brief to fulfill that job, but whether I do it on a Wednesday afternoon or on a Friday morning, largely that's my choice.
But that's your contract of employment that allows you to do that.
Yeah.
My contract of employment tells me I'm working from 9 to 5:30, and I don't have the choice to decide, well, today I'm going to do my work between 7:30 and 9:30 p.m. because my contract tells me when I'm doing it. If I were self-employed, then I would have some degree of autonomy about that.
Yeah, I mean, I think it's however you look at it. I mean, we can split hairs all afternoon, but
Yeah.
At the end of the day, it's a grey area, and there is no answer to this. I mean, that's my point, really. It's so grey that actually it's subjective to the point of,
Well, it is to an extent. The problem is when there's a dispute. I think the thing I would certainly, Ali, recommend you have a look at is the previous slide. So when you get the slides, have a look at the Mercedes case, because it's and Chatford Roberts, because it will show you how the courts decide, and the courts deal in grey areas and how they look at it, and they look at this thing called mutuality of obligation. Are you obligated to provide the work, and are they obligated to do the work? And it looks at how you determine who's in control, and it does break it down. And I think it will explain it better than I can. And I think you are right. Of course, there's nothing wrong with using self-employed PAs, but you are ultimately, there is a difference in law about how that will be taken and looked at, and there are different rights that PAs have. So the more flexibility and more control you have over what you want your PA to do, the more you are veering towards a relationship where you are dictating what happens. And if that is the case, it is possible that you will be deemed to be in an employment relationship, regardless of what the tax does. And that's where we are in law at the moment. They've tried very hard to simplify, change the situation. Every suggestion that's made, and there was a big employment kind of consultation a couple of years ago, government consultation, the Matthew Taylor report, and all of the suggestions were kind of, we ended up with the Good Work Plan, and in the Good Work Plan it said the government is committed to harmonising tax and employment law around employment status and simplifying the test. That's the commitment we've had. As to how you do it, any suggestion about how that is done is very often kind of more complicated than what we currently have. So you are right, and you can manage, and it's fine, and the risk is relatively low, but the risk is there. And there are actual cases that have happened in the last couple of years where, when tested, that's the way the tribunal have looked at it. So the way the law operates is to be mindful of rights, because employee rights are hard fought. And what the Employment Tribunal is concerned with doing is making sure that anyone who is treated like an employee benefits from the rights that the law gives them as an employee. So if it can be demonstrated that as a person working, you're treated like an employee but denied the rights that you are technically should have, the law will side in favour with you. So that's where this grey area sits and why we have to be mindful of it. That's not to say don't use self-employed PAs, 100%.
Yeah, see, my approach is the PAYE route. That's always my preferred. If a PA, and lots of people do nowadays, they present themselves as self-employed. They'll give you or they'll offer a UTR number. They'll offer the public liability insurance. Mm-hmm. And I say, right, okay, so I'm going to employ you, or you're going to provide me with a service on Monday, Tuesday, and Wednesday. What happens if you're sick? Well, you have to get someone else. Well, no, then you're not providing me a service then.
Yeah, absolutely.
So, I mean, that's where it falls down. Can that PA reliably send a substitute? And is it appropriate for them to send a substitute?
Absolutely. Yeah.
That's the test that I personally use. If the answer to that is no, then I say, I'm sorry. I don't care where you've been employed before or who's paid you before. I'm not doing that.
Yeah, and I think that's very wise. And it sounds like you've obviously considered the issues and you've got a good take on it. So I think it's very useful advice that you're sharing there about kind of your take on it and how to people should think about it. Absolutely. So thank you for that. And
I've got one more quick question, but I've got to leave very soon. So if you don't mind me asking,
go for it. Thank you for your
I struggle with the whole sort of liability insurance. What would happen if there was an accident? Now, I mean, just to set the context, I think lots of people use the word carer, personal assistant. They use the terms very interchangeably.
Yeah.
Now, to my mind, there's a very clear distinction between the two. So, a personal assistant, and in my personal world, they are a facilitator. I use sort of pure facilitation. So I will do things that I want to do through the hands of a PA.
Right.
But sometimes it's literally step-by-step guidance. Can you pick up that screwdriver? Can you put it onto that screw? And can you turn it anti-clockwise 3 times?
Right.
And now what I struggle with is, I mean, I do sort of quite hardcore hobby engineering. So I might just share a picture quickly with you, if I can. No, I can't do it. Can't share a screen with you. So I mean, for example, I've done, I've restored a vehicle. So that's involved taking the engine out of a vehicle. Obviously, I've got all the equipment. I hire the workshop. I take the vehicle there. Now, in terms of liability insurance, if there was an accident, let's say the hoist slipped and the engine fell on the PA's foot, and bear in mind these people are not mechanics, they're unskilled people, it's me guiding them on how to do a job. That's at the extreme. How would that work if there was a claim? Where would I stand? And with that insurance that I have to employ a PA cover me in that situation?
So your PA is injured while working for you. The work involves, as being your PA, would involve helping you in your day-to-day activities, which might be working on a car under the bonnet.
Yeah, or let's say using a lawnmower, and they don't use it in the right way, and they don't follow my guidance. They cut through the cable, they get electrocuted, for example. Where would I stand?
Well, I can't obviously talk on individual claims, but in terms of your liability doing those tasks, your liability is to provide a safe work environment. If they're injured and they have an accident while you're employing them, following your instruction, providing they're not doing something like an extreme sport that you might need to check with us about whether or not we'd cover it. Day-to-day tasks like gardening, using a lawnmower, even doing things like mechanics with you or for you under instruction would be covered. So they would be covered in the event of an injury.
Okay.
All right.
That's fine. Thank you very much.
All right. Thank you very much for your contribution and questions. I really appreciate it. And you will have my email after today with the slides, I hope. So if you want to email and carry it on, I'd be glad to carry on the conversation. It's really welcome.
Thanks, David.
Great. Good stuff. Thank you. Okay. So, okay, guys, I'm sorry. I know I've taken up a huge amount of time. I'm so sorry. So hope it's been a good use of your time. Just to talk about COVID quickly to finish this off. What you can see there is a kind of timeline, lockdown easing timeline. Now, this slide has changed dramatically over the last month or so. And unfortunately, initially, things looked as though they were going one way. It feels a little bit like we're kind of maybe going backwards a wee bit in terms of the restrictions and the current situation with the rate of the virus, which is obviously worrying for all of us. But there you are. That's where we are. And I think, there are other changes forecast as well. So I think this slide, unfortunately, will be changing again in the next week or two. Just a reminder of where we are. So I'm not going to go over each and everything on there. Furlough timeline as well. I know we haven't really got time to go into this. You'll be aware, I hope, of the concept of furlough. It was introduced on the back of lockdown. For the government said, okay, we're going to introduce this concept of furlough. Incidentally, the word was used in American law and employment law, and this idea that you could put somebody on leave, but not require them to come to work, but keep paying them a percentage of their pay. For the most part, 80% of their pay in England. When the government introduced the job retention scheme. Okay, right. Sorry, somebody in the waiting room. I do apologise. I'm not keeping track. There we go. Brilliant. Okay, so the furlough scheme was introduced to keep people in their jobs, and for most part, any PAs that were told not to come to work were potentially furloughed without accessing the government schemes. Most councils were saying to people, if you didn't need your PA, let's keep them in their job. Let's tell them not to come to work, and you can keep paying them from the direct payment. And I assume, and I remember vaguely, that's what was happening there in Kingston. As you can see from this slide, the furlough timeline, that the scheme, the job retention scheme, the government's job retention scheme is coming to a close as of the 31st of October. The hope has to be that the virus, or the second wave, if it comes, isn't so severe that they need to reopen that. I don't know. It costs the government an awful lot of money, as I understand it. So watch this space. But furlough was, if there are questions about that, it might be easier to answer questions because I don't know where we're all at. So I'll leave that slide in the presentation for you to look at, and you can ask me questions in a minute. Now, in terms of practical stuff for you as an employer, if your PA is returning to work, I've mentioned health and safety today. There are new risk assessments. I will send the risk assessment with the slides that we put together. There's also a couple of others that are out there that I'll include. There's one from Skills for Care, or an organisation up in the north somewhere, I think in Sheffield, who did a very good template that I'll send. They're specific risk assessments for people who are trying to put together, ensure that their workplace is COVID secure. Okay, PPE, I understand that the distribution of PPE, I think, was okay there. If you need it, the local authorities should be providing it. I don't know what KCIL's role has been in that, but if you need PPE to maintain that safe work environment in a COVID situation, you know, that should be available to you. And obviously some core common sense stuff like limiting physical contact and cleaning surfaces is really, really important for the employer to consider. Generally speaking, there's a requirement within all employment relationships to be reasonable to your staff. You know, disputes arising because of employers not providing a COVID secure environment there isn't any case law yet. There isn't anything to go on. So we do have to advise employers should show compassion and empathy for their employees returning to work. Employees, quite rightly, like the rest of us, are going to be anxious. They're going to be concerns about, am I safe at work? So, you know, there is a requirement to, as I say, show compassion and be reasonable. Make sure you are risk assessing. Make sure you are
being reasonable.
Questions. Sorry, John.
Sorry, David, I was doing something else, so I shouldn't have been
oh, okay, no worries.
coming through.
No worries. So yeah, so being reasonable to our staff, making sure we're showing compassion and empathy for them, and having a conversation so that you're risk assessing. If they're not safe, don't feel safe coming back to work, consider their well-being and have those conversations. It's really, really important. Awareness of their travel to and from work, any adaptations you can make to work. Can they come to work at different times to avoid busier times on public transport? Those kind of things we need to just consider. What were they shielding before the shielding was paused? Were somebody they loved shielding, someone they loved and cared for shielding, and therefore they have extra concerns about going out into going back to work, and their kind of risk that they're going to bring the virus back home. So we, as an employer, we need to just take into account some of this stuff. Employees, of course, should follow safe practices as well as kind of detailed here, which kind of mirrors the guidance for employers. What I'll send with the slides, we did do some fact sheets around returning to work. In case you haven't seen them, what I'm going to do is send them with the slides so you can have those as well. So there will be, I hope that's okay, John and Kimberly, there'll be quite a lot of attachments that I'll send to you guys, which you can distribute as you see fit to the group, but they will be there. And please do pass our email address as well, so if anybody wants to email me and request anything, then that's fine, you can do that as well.